that in our last class we started discussion on the first topic, and we started discussion on the definition of word company. Section 2 clause 20 define the word company, and it says company mean company incorporated under this law or under any previous law. Then what is previous law? We have discussed under section 2 clause 67. That means even the earlier law before 2013 statute, and also the law to the other territory to which the earlier statute could not apply it. Just to recognizing all the institutions that are working under any other statute as a company. By this statute, this definition is there. Then we discuss that what is the literal meaning, because this definition is not important from the our understanding of the company. Then we take the help of the jurist, or you can say the learned judge Lindley in the Solomon versus Solomon and Henny. And from there we have come at one conclusion that company is made through incorporation. There has to be member has to put the stock, that is known as the company capital, and then they has to share money, but there must be the incorporation. The word incorporation has been used by Henny, not by the Lindley learned judge. And then we read section 9 of the Companies Act, that making that after incorporation, after registration, the date on which it is registered, the company will become a body corporate. It will have the perpetual succession, can possess the property, tangible, intangible, etc., etc., maybe sue or should. And then we said that what is means the incorporate body, that means the separate legal personality. Then we started that what is a separate legal personality, that is legal persons, natural person and artificial person, the creation of the law. And there we have left. Now I am starting from this. See, there are this concept is very important from the juristic point of view. In the different statute you will find, and there the definition of the person would be an inclusive definition, just to widen the scope of the provision. Like under the Income Tax Act, it's very wide definition. Under the IPC, it's very wide definition. So maybe strictly some entities are not person, but just to give the applicability of the statute to that particular body is treated as the legal person, but that does not make them legal person. Like if you talk about partnership, section 4 of the Indian Partnership Act define that what is meaning of the word partnership. And there under section 4, the definition is that the partnership is the relation between the persons who have agreed to share the profit of a business carried on by all or any of them. So partnership is the relation between the person. And later on also you will not find a provision there it is said that the partnership will be a separate legal entity, can possess the property in its own name. But yes, there are provision like section 14, by that partnership can have the property. Partnership, in the partnership firm name, the account can be opened. These are the some attributes of the personality, but yes, it is not legal person, because an entity, whether it is a legal person or not, we have to see it by seeing the nature, that whether it can be sued or be sued in its own name. The partnership or the firm is the collection of the partners. And similarly, the liability. The liability is joint as the severable. But in the company case, that is not. If the liability is of the company, that would be the company's liability. if you gave money to the partnership, it would be their joint liability, even their severable liability. You can ask the money from both partners together, or you can ask from any of them. Yes, of course, then other will get the half money from the another partner. Now come to the going deeper into this, the legal personality of certain other things that I said, that either the personality is given by the law, like it may be the parliament, like LIC, RBI, or special statute, or by registration under this under Indian Companies Act, and then by virtue of Section 9, after registration, that company will have the separate legal personality. Or the court recognizes, as I said, that like the temple, or someone said about uh, the judgment of the Uttarakhand High Court, where River Ganga was given the legal or recognized as a legal person. Okay. The first is that what is the legal status of unborn child? The personality generally starts from the birth of a person, but in the law, many times unborn person is also treated, or it's their personality, legal personality is recognized. The child in the mother womb is by fiction treated as already born for ownership. In the Hindu Shastric Hindu law, for the partition, the share of unborn child has to be put. Unborn means who is in the womb, not have. Unborn does not mean even who is not conceived. So unborn child means what I am referring, the person who is in the womb and has not taken the birth. Okay, इतना भी unborn नहीं है कि conceive ही नहीं हुआ. So if the portion of that unborn child is not put, then and the child is turned to be the boy, then the share had to be put at that time. Okay, now the same is apply with the by making after 2005, making the girl also as a co-partner. Gift may be made, and they in the transfer of property act, the transfer to the unborn child is also possible. In the criminal law also, IPC, section 312, section 313, 14, 15, 16 deals with injury to the child in womb, है ना. आईपीसी में इस तरह के प्रोविजन है ना, 312, 313. In the civil suits also, prenatal injury to the mother, damages may be recovered under the Fatal Accidents Act 1976 for benefits of the posthumous child. And so for the limited sense, in the limited sense, unborn child is also recognized as a legal person, but not for all the cases. Now come to the legal status of dead man. As I said, that the personality started from the birth and it stopped when a person dies. When a person died, it has no personality. It has no personality. You cannot transfer the property to the dead person because the dead person is not a legal person in the eyes of law. And therefore, dead man no longer the legal person. Dead man cannot cast vote. Dead man cannot do anything. The question is that suppose there is an accused person, because when the dead man, there is no personality, so there is no liability also. Criminal liability भी नहीं होती है. Suppose there is a person A who killed 20 persons, and then he was tried by the court. He was, convicted. He was even in the appeal. He filed the appeal because every accused has this chance. And before the punishment, before the appellate court decide, he died. So what would be the consequence? Yes, क्या होगा? 20 लोगों को मारा उसने, इतना सारा कोर्ट का टाइम वेस्ट किया, सजा होने से पहले मर होया. What would be the consequence of that criminal trial? Babita? Rekha Kumari? Yes, please. Are you listening me? आप लोग सुन रहे हैं ना, मुझे सुन पा रहे हैं?
Yes, sir.
क्या consequence होगा? If accused dies during the trial or during the appeal, what would be the consequence of that trial?
Sir, as the case of P.V. Narasimha Rao and Lakhubhai Pathak, the case was shut down after the death of Lakhubhai Pathak, sir.
No, so that is not that only in the Lakhubhai Pathak, but maybe I think you are taking hint from that case. Yes. See.
Yes, sir. Yes, I am taking the hint from her.
Yeah. It will be abatement. It is not ABET. Abate is not ABET. Abate, like we discuss in IPC abatement. It's not abatement. It's abate. ABATE. Abatement. The end of that proceeding. Section 394 of the CRPC. Not dismissed. Umar, it would not be called as dismissed. Abatement. ABATEMENT. So under section 394 of the CRPC, होगा सबके पास तो. It says that every appeal under section 377 or 378 shall finally abate on the death of the accused. One provision I am telling. Other also you will find out similar. That after the death of the accused, it will finally abate. Okay. And that means that after the death, the personality stops. But there are three things that even take effect even after the death. So the anxiety of living men extend beyond the period of their death. It's the body. Every person has the right to decent, burial or cremation. Okay. The second is, as such, even the dead body is not the property. I think you have read under the Transfer of Property Act. Dead body होती है property. Manjeet, what is the status of dead body? Is dead body a property?
No, sir.
Okay. Second is estate. What he earned, the property the person earned, that would take the effect as per his will if he has made the testamentary disposition. That means even after the death, because will take effect after the death. So even after the death, the words of this person, the will of this person is exercising, it's actually taking effect in law. ऐसे तो हम कह रहे हैं कि उसकी पर्सनैलिटी खत्म हो गई, and so by will. So these are three aspects: body, state, and third is reputation. As such, there is no concept that one can defame a dead person. But if the defamation to dead person have the effect on the living being, उसके जो family के living member है, then also to that reputation also, to that extent it would extend to reputation also. Otherwise, to the dead man, one cannot defame because he has no personality. Okay. Now come to the legal status of the animal. Law does not recognize animal as person because they are merely things and have no natural or legal rights. Yes, there are some statutes that are for benefit. We cannot do violence against the animal. There are some NGOs also, but that does not mean that their status is as a legal person. We have even the beneficiary legislation for the archaeological buildings, that does not mean that those buildings are the legal persons. Animals, as per the Salmand, is mere object of the legal rights and not the subject of them. But in the past, in the Europe, there was some country where, you know, animals were treated as legal person. The conviction was also done. Trials bhi hoti thi. And in one of the famous, the Sutherland principles of criminality, that one farmer crop was destroyed by the mouse, and then he filed the case against the mouse. Whole mouse was caught, and female mouse who are expecting were left, or was not executed till they gave the birth. So this was done in very old time in European country, but in India we don't have, and now we don't have these animals as a legal person. Even the police dog used for detection of the crime and criminal, but conviction cannot be solely on the basis of evidence of the police dog unless it is corroborated by other sporting evidence. So these things suggest that animals are not legal person. Now come to the idol. In the temples we have idol. बिना मूर्ति के, बिना आइडोल के टेम्पल नहीं होता है. And it has been judicially recognized that idol is a juristic person. Law, there is no statute that giving the juristic personality to the idol, but court recognized that idol has a juristic person. And there are reasons also. If this had not been done, then the large amount of offering, where would that go? And the large amount of immovable property. हर गांव में एक टेम्पल होता था जिसमें मंदिरों को दान दिया जाता था, हर राजा दान देता था. And to the immovable property, there is a very important principle of res nullius. That means an immovable property cannot be without any owner. So just to make that possible, the court recognized that temples are, the idols are the juristic person. Temple or idol are even assessed for income tax also. Okay, and they can hold the property, but their position, I think in the last class also someone asked that they are like minor because they cannot sue themselves. But yes, in the name of them can be sue or be sued. And the priest act as the guardian to look after the interest of the idol. So whenever you transfer or someone make the offering to the idol, it is to the idol, not to the priest. An idol can be treated as a unit of assessment for assessing the liability under Income Tax Act. And this is the case of the highest authority before the Supreme Court came into existence. Parmatha Nath Mulik versus Pradumman Kumar Mulik. Parmatha Nath Mulik versus Pradumman Nath Mulik, 1925 Privy Council, where Privy Council had that idol has legal personality. What about mosque? As regard the legal personality of mosque, the court expressed the conflicting view. In one judgment, one high court said that mosque is a legal person. In Mullah Bucks versus Hafjuddin, Mullah Bucks versus Hafjuddin, the Lahore High Court held that a mosque was a juristic person capable of being sued. Okay. But in the Privy Council held a contrary view. In the Masjid Sahid Ganj case, and that means the Privy Council judgment will overrule because that was higher than the Lahore High Court at that time. So in Masjid Sahidganj case, Privy Council observed that mosques are not an artificial person in eyes of law, and therefore no suit can be brought by or against them. And so after that conflicting opinion, now it is settled position that mosques are not legal person. To the Gurudwara, the Supreme Court in the Shiromani Gurudwara Prabandhak Committee versus Somnath Das. Shiromani Gurudwara Prabandhak Committee versus Somnath Das has ruled that like the ideal, the Guru Granth Sahib is the nucleus in every Gurudwara. And Guru Granth Sahib is the holy Granth of Sikh as a legal person. The existence of Gurudwara is because of installation of the Guru Granth Sahib, which is its nucleus. Okay. Now come to the second thing, that personality will be only one of a one person. Maybe one person can act in dual capacity. That does not mean that one person have dual personality. A person, anyone, or you can say no one can have dual personality. But yes, one can act in dual capacity. Like as the same time, one can be father, brother, husband, etc. So dual capacity does not mean the dual personality. For example, director of a company may also be the trustee of trust, and thus he may not have two distinct capacity. Nevertheless, he have two different capacity, but nevertheless his personality remains single. Now there are two type of personality. Yes, Abhishek, please ask.
Sir, sorry to interrupt you in between.
Yes.
Sir, like you were saying that a mosque cannot be a legal person. Sir, I'm not quite
not
sure.
saying mosque cannot be a legal person, but mosque is not a legal person.
Mosque is not a legal person. Sir, in property law in the second semester, we had a case by the name of some Jumma Masjid Markara versus some respondent. I don't know
Yes,
the
yes,
name,
I
but
also know. I know.
sir, so in that case, how was it possible that the
See,
case was filed against?
even these time, even you will find that in the fashion, you will have like in the Delhi University, whether Delhi University is a legal person or law faculty is a legal person.
Sir, of course, Delhi University will be a legal person.
But in many cases, I saw that even the law faculty is also attached as a party. So sometime with the person or sometime with that, they make this type of the thing. But law is well settled, but I appreciate you to put this point and having so much attention towards this case, because I have gone through many jurisprudence books, and there it is well settled. It is written that the mosque is not a legal person, and so that's why. But in many times, like the partnership is not a legal person, but in many statute you will find that the association of person, whether corporated or uncorporated, will be a legal person. So only that thing is there. Otherwise, mosque are not legal person. Abhishek, are you satisfied?
Yes, sir. Thank you, sir.
Okay. Now come to the corporation is of two types. One is corporate aggregate. Corporate aggregate means two or more than two persons come together and through the incorporation they became body corporate. That is corporate aggregate, like company. And another is corporate soul. The person is single, but it is incorporated series of successive person, like the office of this crown in the Britain. So the crown has a separate office of president, office of this Indian Post. So that particular office is, uh, personified, and corporate soul is the incorporated series of the successive person. So it consists of single person who is personified and regarded by law as a person. So king may die, but long live the king. In the Britain, it is said that long live the king, king may die. So person, physical person as a king may die, but the corporate soul of the king authority or that king will not long live that. Are you getting? So corporate aggregate and corporate soul. Corporate aggregate is made by many persons coming together by the incorporation. Corporate soul is by incorporation of series of successive person, but at one time only one person. Okay. And in that the crown has separate legal personality, and king in his natural capacity also have different personal capacity. So if crown decided something, you cannot say that that person did something. The crown did something. Are you getting my point? Guys, please
Yes, sir.
respond. Okay. Then there are some conditions for juristic person, and these are three conditions. One, that there for the corporate aggregate, that there must be a group of person associated for certain purpose. There must be an organ through which they work, and the corporation is attributed legal person. And all these attributes are there by virtue of section 9, like by section virtue of section 3, 2 or more person for private company, 7 or more person for public company. And then of course for one person company it is not fitting true. And then there is the organ that through the office of director they are working. Then there must be the legal recognition like we are recognizing. Yes. And that's why, you can say that in the recent time there is some dilution with the concept of the personality also. Now come to the uh, you know should we the time is stop or should we carry on? Yes. Now come to the next thing. With this I think you come at conclusion that the incorporation of a company has some certain consequences. What? That it will be treated as a separate legal personality. So suppose 7 person went for incorporation of a public company because 7 person is the minimum requirement. And when the company is incorporated, there will be 7 person plus 1 8 person. Suppose in the meeting these 7 person attended the meeting and then there is a bomb dropped on that meeting hall. All 7 person may die, but company will still remain in the existence because company is recognized by law. Company can possess the property. And there is a concept of limited and unlimited. When the company is limited with limited liability, then the partners, not sorry, forgive me, not partners, the members of the company will have the limited liability. So these are some advantages. And with that, the next topic is what are the advantages and disadvantages of incorporation. And all these advantages are, taking the birth from the section 9. A company incorporated or registered under the act have certain advantages as compared to the other kind of business setup. One is the independent corporate existence, that means separate legal personality. Section 9 of the Companies Act 2013 make a company on issuing certificate of incorporation a distinct personality separate from its member. A company does not lose individuality by issuing the bulk of capital to one person. Even suppose in a public company there is the requirement of minimum 7 members. Suppose one member has the out of 5,000 share, the 4,994 share, and rest partner has one share. Such company are also perfectly valid company. And this was the case in Solomon versus Solomon Company Limited. In Lee versus Lee Air Farming, the Lee and his wife were only two members in this private company, and Lee was the director. Lee appointed himself as a chief pilot, and then in a particular accident Lee was killed. And the question was that whether the company can seek the benefit of that insurance. And the insurance company argued that Lee was not the employee of the company. The benefit scheme was for employee. And the question was that what was the legal status of that. The insurance company argued कि भाई ली ही डायरेक्टर है, ली ही कंपनी है एंड ली ही एम्प्लॉई है, so that means it cannot possible. And court said that no, Lee Air Farming is a separate legal personality, but of course it cannot act, it has to act through its director. So when Lee directed, it directed in a different capacity. But you cannot say that whatever the appointment made is made by the Lee. No, it was not made by the Lee. The work done, the activity done by the director is presumed to be done by the company. And so company appointed Lee. Okay. And the motive for becoming shareholder also became irrelevant. The law recognized the existence of company quite irrespective of motive, intention, scheme, conduct, etc. The second is limited liability of membership. In the sole proprietorship also one can do business. In partnership also one can do business. But in limited, in company, there is the concept of limited liability. And so the liability of the partners will be limited if one do the business through that. The next is the perpetual succession. If one do the business through the partnership, the consequences are very well enumerated in the Partnership Act 1932. But in the company, it would have the perpetual succession and there would be no consequence even if many members or all members dies of a company. It has the separate property, separate than the members also it can have. And so there would be no dispute. The property that suppose the company required would be transferred or would be received by the company itself without the interference of the partnership like in the partnership firm. Then the transferable shares, this is the fifth one. Section 44 said that the share and debenture of the company will be movable property and can be transferred, and the place where the sale and purchase of these shares done is known as the stock market. So its share can be transferred, but the same type of the flexibility is not in the partnership. Partnership is the closed group. The confidence is required in the partnership. And there is the instances where one partner has the affair with the wife of the other partners. And the court has dissolved the partnership because the faith or the confidence between the partnership has been diluted. That is not required here. The sixth condition or the sixth advantage is capacity to sue and be sued. Or you can write it. The first is the independent corporate existence. The first advantage is the independent corporate existence. Second is the limited liability of members. Third is the perpetual succession. Fourth is the separate property. Fifth is the transferable share. Sixth is the capacity to sue and be sued. In case of the firm, the partners has to sue, and basically that is the firm name, but that means that the partners together in the yes, Uma. Capacity to sue and be sued. As in the section 9, it is evident because it is a separate, after incorporation, company would be a separate legal personality, and section 9 explain it further कि separate legal personality का मतलब क्या क्या हो जाएगा. Otherwise also we can deduct all those things. So if one do the business in the sole proprietorships, there is always this fear of having the case in his own name. The liability is also in own name. Suppose you are doing the business and you have infringed the intellectual property right of someone, the case will be against you. But if the same is done through your company, then it was through on your company also. So that liability, that type of the flexibility is there. Similarly, when one do the business through the partnership, the other can sue you directly. Suppose person A given given money to the firm B. Firm B borrowed the money from the person A, and firm B has the two partners C and D. Now this person A want to recover the money, and so he sued to the person C. Partnership तो आपने पढ़ा ही होगा. Can he sue only to the one partner? Yes, बताइए. Yes, because the liability of the partners is joint as well as severable. So this person A who gave money to this firm, because firm is nothing, firm is the compendium of partners, it is collection of partners. Okay, and so rather to suing both, he conveniently sue only one of the partner, and then you cannot deny that you have no liability. You have to pay whole amount, but yes, of course, half amount you can recover because law is there under the Indian Partnership Act from your partner. The seventh one is the professional management. In the company can hire the professional managers for doing the business, and in that there is the greater possibility of having more professional skills and doing in the more profitable way of doing business through the company. The eighth one is the finance. In the partnership, there is the limit of numbers, but in the company, like in the public company, there is no limit, and so large number of the people come together, and so there is larger amount of collection of the money for in the common capital of the company. So there would be no financial problem. So finance can be very well, arranged. Company come with IPO in the market with the shares, and then they have the bulk amount of the money, common people money. So these are the 8 advantages. I can repeat again, like one of the student has said. First advantage is the independent corporate existence. Second is limited liability of members. Third is perpetual succession. Fourth is separate property. Fifth is transferable shares. Sixth is capacity to sue and be sued. Seventh is professional management. And eighth is finance. And see, you observe that all of these are actually arises from the section 9 of the Companies Act. But anything that have the advantage sometimes have the disadvantages also. And the name of this topic is advantage and disadvantages. Now come to the disadvantages. There are certain disadvantages also. The first disadvantage is lifting of corporate veil. There is this concept of lifting of corporate veil. And what we are saying that company will be a separate legal personality, company will be a separate legal personality, anything done by the director will not be responsible, company will be responsible. But sometime Some statute even does not recognize in some certain activities company as a separate legal personality. Like under IT, if some company do the crime, there is a allegation, then the person who are in charge would be personally liable. Under the Environment Protection Act, there is also, if the company do the environmental crime, then the person who is in charge would be liable. That means they are not saying, because these person are not doing in their individual capacity, rather in the on behalf of the company, but law is not, respecting the separate personality, legal personality of the company. So this is known as lifting of corporate veil. Sometimes it is done by the judiciary just for the purpose of justice. Sometimes it is by the statute, like two statute I have given name, outside the Companies Act. And in the Companies Act also, there are certain liability where directors would be personally liable, even they are working on behalf of the company. So that does not mean there is only always blanket cover. And this lifting of corporate veil is a very, very important concept as an exception to the company as a separate legal personality. And we will read it into the detailed cases also. And always there is one question. तो ऐसा भी नहीं है कि कंपनी बना ली तो आप कुछ भी करो अब, नो. The second disadvantage is formality and expenses. Incorporation is not an easy process. There are so many formalities. There are so many formalities that you have to fulfill. You have to hire CA, you have to hire cost accountant, you have to hire lawyer, you have to make so much documents. And all this documentation and the process takes time and even money also. Partnership or doing business in your own capacity, or through the LLP, that is the easy way, that is the combination of the partnership as well as company. So limited liability partnership is that partnership in that have the liability of the members is limited one, like the company we have. And many lawyers go for the LLP, not for the company, not for the partnership. Okay, because company also have some disadvantages. Then the third one is the corporate governance. There are the rules of the corporate governance, and hardly you have to follow those rules of corporate governance. And so there is the difficulty. In the partnership, you can manage yourself through the partnership deeds. In the Partnership Act 1932, you will find that every provision is start subsection में subject to the agreement of the partners. यानी partners agreement के द्वारा बहुत सारी चीजें change कर सकते, but that is not possible here under the Company Act. So these are the three disadvantages. I think difference between these three major enterprises by which one can go for the business, LLP, partnership, and the company, we will discuss in next class. And then more whatever left under this first subtopic, and after that in the next class this first subtopic will be over, and then we will move to the second subtopic. Okay, so with this I stop here. If any question is coming in your mind, any query, anything you want to share, ask, you all are welcome.